Tonight, we're looking at a press conference that raised serious questions about political pressure on the Federal Reserve. A prosecutor is announcing subpoenas aimed at Jerome Powell over $1 billion renovation project at the Federal Reserve, where critics argue something's very different is happening. They say there's no actual evidence of crime, and that investigation itself may be an attempt to pressure Jerome Powell to raise interest rates. So the real question becomes, is this about corruption or is it about politics and pressure on the central bank?
So I'm here to speak about the decision that has been rendered in the case involving the Board of Governors of the Federal Reserve System. Now, the American public is fed up with public monies that seem to go into a black hole, especially in D.C., where no one is held accountable. One of the age-old tools that all prosecutors have to investigate any crime, including cost overruns, is a grand jury subpoena. Today, however, in Washington, an activist judge has taken that tool away from us by inserting himself and preventing the grand jury from even obtaining, let alone hearing evidence. He has neutered the grand jury's ability to investigate crime. As a result, Jerome Powell today is now bathed in immunity, preventing my office from investigating the Federal Reserve. This is wrong, and it is without legal authority. In June of 2025, Jerome Powell testified before the Senate Banking Committee, making, quote, questionable statements that did not comport with publicly available documents. And that was regarding the atrocious cost overrun of more than $1 billion. I didn't say million, I said billion.
Wait a minute. The first thing that stands out is that we don't hear anything about evidence. There's a lot of talk about investigation, subpoenas, but I ain't heard nothing about evidence. No documents, no witnesses, no explanation of what specific crime was committed. Instead, what we're hearing is an argument that prosecutors should be able to investigate first and see what they might find out later. Now, normally that might not be unusual, but the person being targeted here is the chair of the Federal Reserve, the institution responsible for setting interest rates that affect the entire country. And that's why people are asking whether this investigation itself may be political. We can't tell.
Again, no response, no compliance, but instead a woe is me video by Mr. Powell falsely claiming that he was being threatened with criminal indictment. And claiming victim status, Powell proceeds to call his political friends in D.C. and around the world to gin up support for himself, all the while refusing to produce simple documents. Now enter local District Court Judge James Boasberg, whose written decision on its face makes clear his antipathy toward President Trump and this administration. He quashes both subpoenas, thereby prohibiting us from reviewing any records and precluding us from submitting records to the grand jury. That grand jury, of course, comprised of ordinary people. Ladies and gentlemen, no one is above the law.
This is where the argument shifts, right? This prosecutor says the judge bathed Powell in immunity. But then that's not really what the judge did, right? What the courts appears to have done is block subpoenas because it believed the legal justification wasn't strong enough. That happens in courts all the time. Judges routinely stop subpoenas if investigations can't demonstrate a proper legal basis. So the dispute here isn't really about whether Powell is innocent or guilty. The dispute is about whether prosecutors had enough justification to start digging through records in the first place.
Irrespective of the legal process, and thus preventing the grand jury from doing the work that it does. So what is the law? What is the law? According to the United States Supreme Court, the highest court in the land, certainly higher than the court that Boasberg is on, a grand jury, every grand jury, has broad discretion to, quote, investigate merely on suspicion that the law is being violated, merely on suspicion the law is being violated, or because it wants assurance that the law is not being violated. In fact, the court says a grand jury may act on tips and rumors. Right here are the cases and the citations from the highest court in the land. And yet this judge is shockingly requiring the government to show something akin to probable cause, and those are his words, probable cause, in order to justify the issuance of a grand jury subpoena. Folks, probable cause is not and never has been the standard that prosecutors in this country need in order to go into a grand jury.
This is the legal core of the argument. She's saying grand juries should have extremely broad authority to investigate even when prosecutors only have suspicions. The judge appears to have disagreed and required something closer to probable cause before allowing the subpoenas. That's a significant legal disagreement, because if courts start requiring prosecutors to show stronger evidence before issuing subpoenas, it would raise the threshold for launching investigations. And that's why this case is now headed towards an appeal. So, stepping back from the politics for a moment, this case could turn into a much bigger legal fight right now. Not about Jerome Powell personally, but about who controls the start of a criminal investigation. Do prosecutors and grand juries have the freedom to investigate based on suspicion? Or can courts step in and stop those investigations before they begin? That question is now headed into the appeals process, and the answer could shape how powerful institutions are investigated in the future. So, stay tuned.